Welcome to Oil and Gas with Energy Law Prof. Let's do a brief aside on loss of title. As we've talked about, with oil and gas title entitled to minerals on land where you don't own the surface, it's possible for that title to get very fractionated over time as it's passed down through different generations. You may have parties who end up with just 1/100th of the title or otherwise, and at times it can be difficult to know who actually has the title to a property, particularly when it's fractionated among 100 or 200 owners. So let's talk about some of the ways that you can lose that title by disuse and through some of the traditional methods of losing property that you may remember from your property class. So one way is through adverse possession. We'll talk about when that applies. Another is through abandonment, which you may be more used to from the example of personal property. Then in Louisiana, there's a very specific way of losing title to property, which is called the liberative prescription. And a lot of states have enacted by law Dormant Minerals Act. So basically, which say that if you've had this small interest that's been severed from the property for a long period of time, we might end up taking that back from you unless you record that interest. Then marketable title acts is another way of sort of dealing with property that's hasn't been recorded through the typical system, as well as unclaimed personal property acts. We'll talk mostly about those first four options briefly. So, adverse possession versus abandonment. So adverse possession, you may remember from property, involves trespasser action plus owner inaction. And we'll talk about the elements of an adverse possession claim. Now, that is basically for states that have real property and oil and gas interests that are governed by ownership in place rules. So as a reminder, earlier in the semester, we talked about those states like Texas, where you are said to own the oil and gas underneath your ground. That's an ownership in place states, and so they use adverse possession rules for oil and gas interests. Abandonment, by contrast, is used in what we call non-ownership states. As we described, that's a bit of a misnomer. You still own the right to produce oil and gas, but instead of saying that you own the oil and gas underneath your property, we just say that you have the exclusive right to produce oil and gas from your property. So sometimes that's called a profit or a profit apprend, and that's the case in Oklahoma. In those states, we use abandonment instead of adverse possession, and that's more like what would apply to personal property, where we say, well, your owner inaction plus some other equitable factor is going to be enough to say that you have abandoned that property. Finally, those dormant minerals acts, remember, those are in states where maybe, and a classic example is Ohio. There was an oil boom early in the 20th century, and then there wasn't much oil development ever since then until a recent oil boom. And what happened is that because there were years and years and years after the first oil boom, during which people had bought shares of minerals and transferred it to their kids, etc. But then there were years and years where people weren't paying attention to who owned the minerals because it wasn't really a very valuable industry in Ohio during that period of time. Then the interest in that land got fractionated over time, and people didn't even pay attention to who may have inherited it in a will or otherwise. Now that the oil and gas industry comes back to Ohio and wants to drill, it's trying to figure out who owns the oil and gas under this property. Was it severed, 100 years ago, and now it's been passed down to 200 descendants? Who do they have to contract with to develop that property? And the solution that sometimes states look at is enacting a Dormant Minerals Act, which says, hey, if you have a fractionated share of a mineral interest where there's a surface owner, go ahead and notify that, record it. Otherwise, we're going to send it back to the surface owner just to unify title in the surface owner, and that's going to make things much easier to develop going forward. Let's talk about adverse possession. Remind you of what the elements of that are. First of all, the possession has to be actual with exclusive possession. So you can't just say, oh, I own this property. You have to actually be occupying it. It has to be open and notorious, which actually gives the real landowner some ability to check that land, see if you're there. It has to be adverse and under claim of right. It can't be just permissive. So you can't just sleep on your friend's couch for long enough and then say that you own it. If it's permissive, it doesn't count. It has to be continuous. So that means you can't leave and come back. Now, the slight exception to that is it's okay if one adverse possessor claiming the property sells it to the next one. You can put those two time periods together if they are in privity. So if one party sells the whole property to the other. So those, as a reminder, are the elements of adverse possession. We've talked about adverse possession applies in those ownership in place states. Abandonment applies in those non-ownership in place states. The other example that I told you about was the liberative prescription. That's only in Louisiana, and what that says is if you separate the minerals from the surface, the longest it can last is 10 years. And after that, it goes back to the surface owner. And the reason for that is that just simplifies things in terms of now surface owners, if they know nobody's separated the minerals from the surface estate in the last 10 years, then it belongs to you because the liberative prescription after 10 years sends it back to the surface owner. We'll talk about that again in the context of leasing. And then the Dormant Minerals Acts and marketable title rules, as I say, it really depends on what the states have enacted in terms of the rules that say if you don't register this interest, this fractionated interest, you're going to lose it.